Hey everybody, this is TJR. Normally, when I talk about a music copyright lawsuit, it involves an accusation that one artist has copied another artist's song to the point where it is considered plagiarism. But the ongoing lawsuit from folk artist Tracy Chapman against Nicki Minaj is quite different, and it's been going on since 2018. And I haven't had the opportunity to comment on this particular lawsuit until now. But recently, Nicki Minaj has released a statement to the press basically saying that if there is any summary judgment against her in this case, it will have serious repercussions for the entertainment industry. And it is this statement that has prompted me to make this video. But before we go further, if you like this type of content, please be sure to click a like, click subscribe, and be sure to click the notification icon so you can know when I release new videos. Also, if you want to take that extra step, you can go to the Patreon page. Patron supporters receive early access to selected videos and exclusive Patreon content. The lawsuit stems from the 2018 release of a track by Nicki Minaj entitled Sorry. Sorry samples the 1998 track Baby Can I Hold You by Tracy Chapman. And this track was supposed to appear on her fourth studio album entitled Queen. Sampling another artist's song to create a new song has been common practice within the hip-hop and rap music industry since its inception. And originally, there were no legal precedences for this practice, but over the years, the legal rules regarding sampling have evolved. And in the present day, if you are going to release a song that samples the work of another artist, you must get the original artist's permission, you must credit them in the songwriting, and you must pay the original artist their share of royalties generated by your new song. Now, most artists do not mind having their tracks sampled by other artists as long as these legal protocols are adhered to. And most will give their permission because it provides a new revenue stream for them, which can, in some cases, be a real godsend for some songwriters, especially if your older hits have seen better days financially, so to speak. But with that said, it's important to understand that any artist can refuse. Nicki Minaj was unable to get permission to use the sample of Baby Can I Hold You from Tracy Chapman. Tracy Chapman refused. And she has a reputation within the industry for not allowing samples of her songs to be used in other songs. Now, according to Nicki Minaj, she elected to keep the song off the album since she couldn't get clearance for the sample from Chapman. However, on the day following the release of her album Queen, radio DJ Funkmaster Flex played the track Sorry, even though it wasn't released on the album. Where did he get the track? Allegedly from Minaj's team or perhaps Minaj herself. Once again, reports vary on this part of the story. And prior to it being played, Nicki Minaj sent out a tweet where she expressed how torn she felt about not being able to release this track. Tracy Chapman issued DMCA takedown notices for copyright infringement, which is her right, after fans of Minaj who heard the song when it played ripped it and then uploaded it to the internet. Because of this, Tracy Chapman formally sued Minaj for copyright infringement, with the singer's attorney, John Gotti, hopefully I've said that right, it's spelled G-A-T-T-I, saying Miss Minaj violated Miss Chapman's copyright by creating an illegal derivative work and distributing that work. Moreover, these actions were indisputably willful. Miss Minaj had knowledge of the illegality of her actions and proceeded. Thus, Miss Chapman's copyright claim is appropriate for summary judgment. Now, at this point, I'm gonna quote from an article in Digital Music News. However, this story has been all over the internet from various sources, basically all saying the same thing. Let me just read the following here. In its defense, Nicki Minaj's legal team argues that an experiment and, quote, process of creation shouldn't be subject to copyright infringement. Now, just off the top on that statement, I agree with that. But there's a little bit more to this, and we'll get to that in a moment. In the process of creation, no one approaches the original songwriter for a license to experiment. Her attorneys state in the court briefing, the musicians just experiment. If something works and the recording artist wants to release the song commercially, then the record label, managers, and attorneys get involved and seek the required permission. If it is granted, the recording is commercially released, and if permission is denied, the recording is discarded. No one is harmed, and the experimentation begins anew. Once again, at this point, I have no problem with this. Recording artists require this freedom to experiment, and rights holders appreciate the protocol as well. Once again, no argument from me on that. Now I'm going to turn to an article here. I'm going to quote from Hip Hop DX, an article by Kyle Eustace. One of Nicki's lawyers, Eric George, explained, the plaintiff here, Tracy Chapman, wants to turn this process on its head. It's argued U.S. District Court Judge Virginia Phillips should rule Nicki's demo recording of Sorry made fair use of copyright because it was basically pure purpose. As the brief pointed out, indeed, creativity would be stifled were artists required to seek and pay for a license before even experimenting with a work. Complicating the issue is Nicki herself. She released the song knowing the sample wasn't cleared, but as the Grammy Award-winning rapper warned in court papers, any legal loss for her on this subject should send a shiver down the spine of those concerned with the entertainment industries. So basically, Nicki Minaj and her team are arguing that, one, it was a demo and it wasn't commercially released. So therefore, she's not guilty of any copyright violation. And on just that alone, I would say I agree. She's not guilty. She just made a demo. She didn't release it commercially. She's also stating that the jury has to judge in her favor, or this would be a huge and devastating blow to the hip-hop genre. In fact, in a recent interview with OK Player, one music industry lawyer, Carl Folks Esquire, has stated that the implications would be horrific to the genre of hip-hop, since sampling is a huge component in hip-hop. So I just want to say the following. I understand that the creative process includes experimentation. And if you are going to be sampling the music of others, you should need to get clearance for any samples while you are still in the experimentation phase. And it is true that she did not release the song commercially. But if she willingly took part in allowing this song to be played on a major radio and internet platform, then she knowingly took part in its illegal distribution, which allowed her fans to digitally copy it and post it elsewhere on the internet. Copyright, in its simplest definition, means the right to copy or the right to make copies. And when Nicki Minaj and or her team made her demo available on a radio and internet platform, they gave her fans the ability or the right to copy it, something that Nicki Minaj had no right to do. So now, what about this second argument, that a ruling against Minaj would stifle creativity within the hip-hop genre and send a chill down the industry's spine? I don't believe that. I think that the argument by her attorney, Eric George, that creativity would be stifled were artists required to seek and pay for a license before even experimenting with a piece of work, and it's an argument that she is, of course, repeating to the press. I believe this argument is a deceptive argument. It's a scare tactic to draw attention away from the real argument. To the best of my knowledge, and from everything I've read on this, Tracy Chapman is not suing Nicki Minaj for experimenting or experimenting with one of her songs. She is suing her for distributing it on a platform that allowed others to copy and distribute it, which did violate Tracy Chapman's copyright. Nicki Minaj made this track available for distribution when she did that. And I know there's been some back and forth about how involved Nicki Minaj was with this, but once again, If she was involved, then she and or her team are guilty, in my opinion. If a court rules in favor of Tracy Chapman, we aren't going to see huge swaths of songwriters and recording artists suddenly swooping down on hip-hop artists and their producers because they are experimenting with samples in their attempts to see what they think might be their next big hit. That's not going to happen. And for all the reasons I stated earlier. I think that business will carry on as usual because the majority of all those artists and songwriters whose older recordings they are experimenting with are still just as eager to see their old recordings gain new financial legs as Nicki Minaj and her producers are. So long as they don't commercially release it without first following the legal protocols that have been in place in regards to sampling for decades now. And that includes not illegally distributing it. Those are my thoughts, but I am open to hearing yours, even if you disagree with me. Musical copyright lawsuits like these can bring out a lot of heated passion amongst artist fans, and that can lead to saying things you might later regret. So I just ask that please go ahead, express your feelings, but please keep your comments respectful to everybody. Everybody, thank you so much for watching. Hope you all take care. Hope you all stay safe and healthy. Bye-bye.